I'm Rex Buchanan, the former director of the Kansas Geological Survey. The date is February 5th, 2021. I'm at my home in Lawrence, Kansas, interviewing KU Law Professor Emeritus John Peck, who is at his home in Mission, Kansas. We're conducting this interview over Zoom. John is a native Kansan and graduated from Kansas State University in 1968 with a degree in civil engineering. After working 3 years for the U.S. Public Health Service and the EPA in Washington, D.C., he earned his law degree from the University of Kansas School of Law in 1974. He practiced law in Manhattan, Kansas from 1974 to 1978 and joined the KU Law faculty in 1978. He taught contracts, land transactions, water law, and family law. John is a nationally recognized authority on Kansas water law. After 41 years of teaching at KU, he retired in 2019. He remains in law practice in an of counsel position with Foulston Siefkin LLP in Overland Park. Representative clients include municipalities, power plants, and other industries, irrigators, golf courses, and special water districts. John's interview today is part of the Kansas Oral History Project series, examining the development of water policy during the 1970s, 80s, and 1990s. In these interviews, we explore water policy through the eyes of water experts, administrators, legislators, farmers, environmentalists, and others who were involved in development and implementation of that policy. The Kansas Oral History Project is a nonprofit corporation created to collect and preserve oral histories of Kansans who were involved in shaping and implementing public policy during the last half of the 20th century. Recordings and transcripts of these oral history interviews are accessible to researchers and educators online at ksoralhistory.org and through the Kansas Historical Society and the State Library of Kansas. The Kansas Oral History Project is supported by donations from individuals and grants from Evergy and Humanities Kansas. John, thanks for agreeing to do this today. I appreciate you taking the time. Let's start a little bit with your background. You grew up sort of north central Kansas and went to K-State, got a degree in engineering, did wind up after a few years in going to law school. In my experience, that combination of backgrounds in engineering and the law is pretty unusual. What brought that on?
Rex, when I was in engineering school, the Vietnam War was just starting up, and in the late 60s, I received my draft notice, and I thought I was going to probably go to Vietnam, but then I found another branch of the service that most people have never heard of, the Commissioned Officers Corps of the U.S. Public Health Service, which at that time was taking engineers in addition to medical people. And so I applied for a position with the U.S. Public Health Service and got into that service with the help of Senator Carlson, who happened to be from Concordia, and he wrote a nice letter on my behalf. And so I spent 3 years with the Public Health Service in Washington, D.C., and I was assigned to, at first, the Public Health Service National Air Pollution Control Administration. And then when those departments, water and air and solid waste that were formerly in the Public Health Service were transferred to EPA, then I was moved lock, stock, and barrel over to EPA. So I was actually in the room when EPA started and Bill Ruckelshaus was named the first executive director. But in any case, that's when I began to get away from pure engineering. I mean, I was writing reports on air pollution and helping to establish the so-called air quality control regions around the country, appearing at public meetings. But I began to work with some lawyers, and frankly, I guess I'd met one lawyer growing up. That was a judge who handled my Boy Scout merit badge and citizenship in the community or something. But in any case, I began to work with lawyers, and I saw how they worked with legislation, and that's basically what we were doing. We were implementing legislation. And I got more and more afraid to go back into graduate school in the mathematics. The more I got away from mathematics, the more afraid I was that I couldn't make it in graduate school. I always wanted to go to graduate school, and I slowly evolved to law. And it had nothing to do with water at that time. It just had to do with a change in my thinking about what I wanted to do for a career. And I saw law as having the potential for a lot more grayness than the black and white that I was kind of felt like I was taught in engineering school. So that's a long answer to a short question, but that's how I got into law. It was just an evolution in thought.
I have a follow-up question to that, but let me, grayness versus black and white. What do you mean by that exactly?
Well, by that, I mean that my training in engineering school was to study various subjects like statics and dynamics and strength of materials and that kind of thing, and learn some formulas and learn how to apply those formulas to various problems and to come up with an answer on an exam. And it seemed to be fairly clear cut. I mean, it had an answer.
The answer was either right or wrong.
The answer, well, we had to show our work, but the answer there seemed to be a mathematical answer. When I got into EPA and saw that these lawyers were arguing all the time about what this word meant or what this statute meant, or how do you apply this statute to a set of facts, I grew much more comfortable with that kind of thinking. And that's one thing that I have relished about my law training and my practice, is that there always seemed to be at least two sides to every question, and there are no really black and white answers, as we see in the current situation with the impeachment and all that news.
There's room for ambiguity, which
Absolutely
is pretty much true of life as opposed to other components. Let me ask you this, because in working with you over the years, it seemed to me that your engineering background really came in handy and helped inform your legal background. At least that's how it seemed to me.
No question
that right?
about it. I mean, I took some water resources courses in engineering school, not thinking that I'd ever become a lawyer and do water law. But I think that background in hydrology and hydraulics, and I think I even took a course that included some dam design. But my training in mathematics has actually helped me. I mean, for example, as you know, the groundwater management districts have some regulations that actually contain algebraic formulas, and they set forth the algebraic formula in the regulation, and they tell what all the terms mean. And it's been fun for me to try to translate that into English for people to be able to understand. So I don't think there's any question a technical background has helped me.
It also gives you, I think, a certain level of credibility that other people in the legal profession don't necessarily have when they wade into technical issues like the world that I'm accustomed to. Just the fact that you have that background, I think, provides a level of comfort that's a little unusual.
Well, I'll tell you what, it's not really earned, I don't think, Rex, because I haven't had to prove myself in testimony anywhere that I actually understand. I mean, anything about modeling or anything like that, I have not had to do any of that. So I agree. I think it helps me. It gives me kind of a stamp of approval when I am introduced as an engineering graduate and a lawyer. That helps. But I'll tell you, most of what I learned in engineering school, except the process of thinking, which I am very, very grateful for, most of that has been lost.
let's move on a little bit. So, in terms of, you practiced law for a little while after. So when did you develop this interest in water law? Is it at what point does that become one of the things that you specialize in?
That's really interesting, because in law school we had a really good law professor who taught water law, among other things. His name was Earl Schertz, and you've heard of Earl Schertz because he wrote several of the very important early papers on Kansas water law back in the 50s and the 60s. But I didn't take water law. In fact, I don't even remember even considering taking that. We had a whole plethora of courses we could choose from. And the thought that I would ever end up with a water law case, well, I'm not even sure I even knew it was in the curriculum. So I went to Manhattan because I had gone to K-State. I loved Manhattan. My partner there, one of them was Richard Seaton, who was a K-State attorney. And I didn't have any water cases in Manhattan, although our firm did have one that involved some kind of a drainage question. But otherwise, I'd never heard of the Appropriation Act or anything. So I was then contacted by Dean Martin Dickinson of the law school, who asked me to consider moving from law practice to the faculty, which came as a total surprise to me. After a few months of thinking and visiting with my wife about it, we decided, okay, we'll interview for that job, and I got that position as an associate professor. And so I got down to KU to visit with Martin Dickinson, and he said, well, what would you like to teach? And I said, well, contracts and land, because that's the kind of work I've been doing, and maybe family law, because I'd handled some divorces and adoptions. And he said, well, what about water law? And I said, water law? I don't even know what that is, Martin. I didn't take the case. And he said, well, Professor Schertz has become disabled, and there was a Kansas Water Resources Board report, interim report, the year before that highly encouraged both KU and Washburn to teach water law. And he said, we would like you to teach water law if you're willing. And I said, well, okay, I don't know anything about it. But if this would have been in the spring of 77, and then or in 78, and then I started teaching in the fall of 78, and I didn't have to teach water law until the spring of 79. So I wondered, how am I going to learn anything about this? And I contacted Jim Power of the Kansas Water Resources Board. He was the head then. And I said, Jim, I'm supposed to teach water law here, and I don't know anything about it. I said, I have a case book I can buy and use, but I said, I need some help. And he said, well, first of all, I'll send you all the publications of your colleague, Earl Schertz, Professor Schertz, which he did. And by the way, Rex, those publications are still highly valued by lawyers in the state. We read them, we discuss them, we argue about them. I'm talking about the small water rights fraternity. And so he sent me those, and he said, well, better yet, John, I'd like to hire you to work on a project with us. We've been asked by the federal government to look into the possible movement of water from the Missouri River to western Kansas. And we'd like somebody to do a legal study of that. Would you be interested? And so that's how I began to cut my teeth, was to prepare for teaching that class in the spring of 79, to begin to work on the legal aspects of moving water from the Missouri River to western Kansas, which was just fascinating and still is. And then to prepare for my water law class and to teach it. That's how I got started.
So you were teaching a course that you never took.
That's right. That's right.
So how did then your involvement, it goes from the Water Resources Board to eventually the Water Office and Water Authority, and changes in sort of the regulatory and administrative mechanisms of dealing with water in Kansas. does your involvement then continue with those organizations as they grow and develop? Talk about that a little bit.
Okay. Well, in Lawrence, we happen to live right next to Joe Harkins, and the former Kansas Water Resources Board, which at one time I think had the executive head was Professor Bob Smith of the Civil Engineering School at KU. But the legislature changed that to the Water Office in the early 80s, I think it was. And they had one director, and then they brought in another director by the name of Joe Harkins. Well, Joe Harkins happened to be our neighbor in Lawrence. And I didn't know he knew anything about water. And in fact, I learned that he may not have known much about water, but Joe Harkins is one of the best administrators I've ever encountered. And I think Joe to me is like a CEO of a major corporation. If it's GM, that's good, but he can move over to head a drug company, or he can move over to head a software company because of the skills as an administrator. So Joe Harkins knocked on my door one night and he said, "John, we're starting to work on a water plan, a new water plan, and I need somebody inside, a lawyer who can analyze some of the legal aspects of this new water planning process." And so I said, "What do you mean? I don't want to leave KU." And he said, "Well, would you be willing to come over here for the summer and the fall of, I think it was 1984 or so?" And so I talked to my dean at that time, and he said, "Sure, we'll let you go for that amount of time." So I began to work with the Kansas Water Office and Joe Harkins, and there were several developments out of that for me personally, Rex. The first was that I said, "I don't even know what the water plan is, Joe." And he handed me a copy of the very first so-called water plan. I still have the copy. It's maybe 15 or 17, 19 pages long. It's yellow with age now. But it was set in some kind of font, and then there were drawings and there were graphs in there. And he said, "Well, this is the water plan." And I looked at the statute, and it says that the legislature at that time was supposed to consider and incorporate the water plan into the law, incorporate it. And I looked at that document and I looked at the legislation, and it looked to me like maybe the legislature had incorporated that document. And that really bothered me because, first of all, it wouldn't appear in the Kansas statutes that all lawyers use. You know, we all have those red books behind our desk. We pull them off and we read them. And I learned that there are some other things that have been incorporated by statute, incorporated by reference in the Kansas statutes. For example, the Internal Revenue Code is incorporated into our law because our state income tax is based in part on the federal figures. I think maybe the National Traffic Code maybe, or something like that. But you can actually get a hold of those copies easy if you have to, if you're a lawyer. But this little pamphlet didn't look to me like a water plan. And so I wrote Joe, that was the first memo I wrote in the summer. And that was the first change that was then made in the following legislative session, was to change the language so that they don't incorporate the water plan into the statute, but rather it became a dynamic process by which the State Water Office every year or whenever produces more versions of the plan, which are sent to the authority, which are sent to the legislature to be considered, and then they could pass legislation. And based on that, they passed, for example, the Water Assurance Act. Assurance District Act. And I remember that fall of 1984. That was one of my first assignments after that memo, was to write the first version of the legislation for the Kansas Water Assurance District Act. And I had never written legislation before, and I found out how hard it is to write legislation, even a draft. And so that was my first big project after that. And I am forever grateful to Joe Harkins for hiring me and giving me that opportunity. And I admire him greatly.
I just want you to know, John, that I have had water assurance districts explained to me multiple times, and on rare occasions for about 5 minutes, I think I understand what they are. And then that goes away and I'm still confused by it. And now I know who to hold responsible for that. But Joe was the first person that we talked to in this series. And I would kind of like to go back and talk to him again after we get finished up, because you're exactly right. He brings an approach, an administrative approach to water that was, it seems to me, hugely influential, even though he didn't have much of a water background in this process. You almost make it sound like a fair amount of what happened to you career-wise is almost accidental. Somebody calls you and asks you to teach a course that you've never taught. You happen to live next door to Joe Harkins. It sounds kind of coincidental almost.
Absolutely. In fact, I had to give a little talk about this subject of kind of my career a couple of years ago. And I attributed everything in my career to 4 out of the blue phone calls. And the first one was Martin Dickinson asking me to consider moving to KU. The second one was by a farmer east of Lawrence in 1979 or 80. See, what happens, Rex, is that I published an article on that Missouri River transfer possibility. And then I published an article on groundwater management districts. That was my first big article. As you know, law professors are supposed to publish. That's half of what we do. And that's where we help make our name and give us some credibility in the practicing bar, either locally or statewide or nationally. And so we publish what are called law review articles. And a law review is a publication that every law school has in the country. We have 2 at KU. And they're edited by students. And part of each issue is written by students, but they also have these articles. And that's the way we learn, and that's the way we disseminate our knowledge. So what happened was I wrote that article on the Missouri River. Then I wrote one on groundwater management districts that was funded by the KU research grant back in 1980 or so. And then your name begins to get out there, like you supposedly know something. So back to the phone call I got from this farmer named Mr. Ott, east of town. He said, Mr. Peck, I have a water right and I'm irrigating corn, and for some reason I'm not getting any water. I'm not permitted to get any water out of the Wakarusa River this year, and I'm looking up at Clinton Reservoir and they're all water skiing up there. And I have a water right that predated that lake. What's the deal? And so I said, well, I don't know. I'll try to find out. And so it was there that I learned about the Kansas reservation rights that the state gets to fill and to keep water in the big federal reservoirs, and how they relate to the priority system in the Appropriation Act to downstream and upstream farmers and other people. And so what I did from that, Rex, was I gave him some kind of an answer that probably didn't make him happy. And then I wrote an article on federal reservoirs. And then that article was probably my third one. And then it just kind of tumbles like that. You get your name out and then you get more calls, etc. So let me just interject. The other two phone calls, and then we can pursue them if you want to, the third one was in 1988 or so, when the city of Wichita legal department and city manager called me to see if I would help the city of Wichita acquire some groundwater rights. And that started my consulting in groundwater, well, in water rights in general. And then the fourth call I got was in the early 2000s, when I got a call or an email from Sri Lanka asking me to do an international project. So your question is right on point, Rex. These things have just come out of the blue for me. Very fortunate, and each one has changed my life.
What the article about groundwater management districts, GMDs, we've talked about them a lot in this interview process, because they appear to me to be the epitome of the philosophy of the value of local control versus state control. What was your perspective on GMDs at that time, and what is it today? Have they fulfilled that promise, do you think?
That's an interesting question, because we did a whole symposium on that question in about 2006 in the law school. But Rex, when I first took on that subject as a scholarly interest, it's just because I had to find some topic to write about. I'm serious, as a new law professor in water law who knew nothing about water law, I did look at the recent session laws, the session laws, which is the compilation of laws that have just been passed by the legislature in 1979 or so. And I saw that there had been some amendments to the Groundwater Management District Act, which was enacted in 1972. And I thought, okay, I'll write an article on groundwater management districts. So my wife and I piled the kids in the car, and we took a trip out to western Kansas in the summer of 1980. And if you look at your weather information, you'll see that was maybe the driest summer we've ever had in my lifetime.
I remember that summer. It wasn't just dry. It was hot. I think there were almost like 30 consecutive days of 100-degree temperatures. That was an ugly summer.
Yeah, and my sons were trying to play baseball, and they'd put the evening games off an hour. But that's also the summer I received that phone call from the farmer east of Lawrence. So I wrote that article not knowing anything about groundwater management districts, and I tried to analyze that statute, every word, to try to look for potential problems and lawsuits and that kind of thing. And I think the one that sticks with me after all this time, and is still an issue with me, is the fact that the original Groundwater Management District Act, which enabled the creation of the groundwater management districts, was amended in 1978 or 79 to add the possibility of these IGUCAs, the intensive groundwater use control areas. And the one new power that was given to the chief engineer that bothered me, and I'm talking about bother, not from a moral sense, but rather from a sense of potential legal problem. Remember, I see things on both sides, so I'm just trying to raise the issue, was the fact that the chief engineer seemed to be given the power to cut back on water rights outside of the priority system, which the Water Appropriation Act of 1945 seemed to set in stone. And so I raised that issue first in that article in 1981 or whenever that article was published. And the same issue existed when we had the Cheyenne Bottoms IGUCA, which I know a little bit about. It still exists with the local enhanced management areas, with the LEMAs, but not with the newest district. I forget what they're called at the moment. was totally voluntary on the part. So I raised that issue way back then. That was the first main problem I saw with that act.
Because that priority system is sort of foundational for water law in Kansas, first in time, first in right.
Yes.
And anything that violates that seems to violate the foundation of water law, right?
Well,
As I understand.
In theory, the background is the U.S. Constitution's protection of property. And in 45, we enacted the act that set into place the priority system. In 1957, after Professor Schertz's recommended changes, they added a section that said that water rights are real property rights, which means that they're like real estate, like land. And the federal Constitution protects owners of land from having the land taken without compensation. So it was my thought at the time that if one has a water right for so many acre feet and the government comes in and reduces that water right, that is a potential taking. And that's still an issue nationwide. Lawyers are still arguing on either side of that.
How were you involved in the Cheyenne Bottoms IGUCA and the development of that? That was a big deal. Dave Pope talked about it a fair amount. And as I look back on it, it looks like a successful resolution of what had been a very difficult problem. What was your role in that?
Well, it was kind of a limited background role, but I was certainly in the forefront of being able to witness everything. So in the late 80s, when the Cheyenne Bottoms was having issues filling up its pools, I think we had a dry spell in the late 80s, and the Kansas, I think it may have been the Fish and Game Commission back then, or I don't know if it was Parks and Rec. I can't remember when that change took place. But they had a very early water right for a large amount of water from both Walnut Creek and the Ark River. I think it was 50,000 acre feet a year. And so there were complaints, I think, by the Fish and Game Commission to the chief engineer, hey, you've got to help enforce the water right here. There was a serious issue about whether you could integrate groundwater and surface water rights where the nearby irrigators in the alluvium affecting the stream and the Walnut Creek and then the Ark River. And so I know some meetings were held out in Great Bend that I wasn't privy to. This is before I became involved. Then when it looked like they were going to pursue this IGUCA, some farmers out there banded together. I think there were two different groups. One was Pack, Water Protection Association of Central Kansas. And the other, I think, may have been the farmers who were directly involved in the Walnut Creek. I think that's my recollection. Each of those were represented by a lawyer in Great Bend. So there were two lawyers in Great Bend. And I got a call from one of them saying, you know, we're representing these farmers and we're very concerned that the state may come in here and try to regulate them. Would you be interested in just coming on as a consultant for us? And I said, well, sure. And so I was actually just a consultant. I didn't take part in any hearing except to attend and then to take part in meetings. But Rex, the whole setting was so interesting to me. We had a series of hearings in the Holiday Inn in Great Bend. And this is in the winter time when it was snowy and icy. In fact, my wife, Pam, took her ice skates out for one of these and ice skated in the Cheyenne Bottoms, which was an unforgettable experience for her, being alone with nobody but birds. And so at this hearing, I think there were 12 different parties and each one had a table. It wasn't like a courtroom, you know, where you have two tables. You had 12 tables in the ballroom of the Holiday Inn. And up front was David Pope, Rebecca Liggett, a former student of mine who was his legal counsel at the time. Lee Rolfs wasn't working on that case. He did everything else, but he didn't do that case. And then they would bring up the witnesses. But at the tables were the city of Great Bend, the city of Hoisington, the Groundwater Management District number 5, Water Pack, other farmers, the Kansas Sierra Club, the Kansas Audubon Society, represented by Frank Ostenfeld and John Simpson, all both very capable lawyers. And so we had, I don't know how many days of testimony. And then there was a couple of evenings where they allowed the public just to come in and comment on the question of whether the state should control these water rights of the farmers, the upstream alluvial irrigators, to protect the water in the Cheyenne bottoms. And one of the most striking bits of testimony, as far as I was concerned, was brought by, I think, the environmental interests. And he was an ornithologist from Boston and a very impressive looking guy, looked like an opera singer. And he came in and I'll never forget, he said something like, when asked the question, how important are the Cheyenne bottoms? He said something like, the Cheyenne bottoms, in my opinion, is one of the most important migratory bird stopover points in the Western Hemisphere. I mean, that really had an impact. And he talked about how they would ban these shorebirds, which are birds that have the long, spindly legs, and they would weigh them before they fed in the muck to get a few more grams before they flew south to South America. And the long and short of it was, as you said, David Pope and the Division of Water Resources came out with kind of a compromise solution. And by compromise, I mean the chief engineer did not enforce priorities perfectly. In other words, it is true that there were something like 800 upstream irrigators, most of whom were junior in priority to the Cheyenne bottoms right. And what Dave could have done would have been, okay, we're going to shut down the junior most until we finally get the amount of water we would like for the Cheyenne bottoms. But instead, he set up two classes of water rights. One he called senior water rights and one he called junior water rights. And the senior water rights, if I recall correctly, had dates of October the 1st, 1965 and before. And the junior were after that or something. My memory's a little cloudy on this. But he then cut back the senior water rights only to the amount that he thought would keep them from wasting the water. And that idea had been found constitutional in a California case, that if you have, say, 36 inches of water and you really only need 30 or you're wasting the other 6, the state has the power to cut back that without a claim of taking of property. But the junior water rights, he cut back substantially, like 60 or 70%. And this goes back to my article, Rex, on whether that was a taking of property or not. Well, the farmers, of course, felt that they had lost, and they filed an appeal of that decision. But then the chief engineer, I think, offered, now Dave could confirm this or not, but as I remember, he offered to let them pump at the same rate for 1 more year if they would accept the order and drop the appeal. And I think that's what happened. So from that case, we have no resolution of the question of whether that order was constitutional. We still don't have that resolution.
And that may not necessarily be a bad thing. I mean, and the reason I think this is really important is everybody involved, and I'll give Dave a lot of credit for this, engineered a solution that was the result of a lot of conversation and a lot of consensus building, right? I mean, it looks to me like a model, and I know you don't have the similar kind of background on Quivira National Wildlife Refuge, which is going through a similar thing, only from a federal point of view. But it does seem to me like what happened there is sort of a roadmap for how things maybe ought to happen. I mean, is that, what do you think now, looking back, however, 30, 35 years after the fact?
Well, I have to admit that I have admired that order. But, you know, you're kind of asking the wrong person here, just because when I was involved as a consultant trying to argue the other side, and that's what lawyers do, whether the public likes it or not. We're hired
Right.
to do the best we can and make the best arguments we can for the side that hires us, as long as it doesn't go against some moral principle that we have. And your question about, you used the word ought, which is, of course, the basic question in moral philosophy, but whether something ought to be done. But I have told Dave personally that I admire his decision in that case. And I think it's gotten a lot of play nationally. I have talked about that decision at national meetings and at international meetings, and I haven't given a position either way. I'm just saying this is the way this decision was made, and that we still don't have a resolution of the order because the appeal was dropped.
Real quickly, I want to go back. I'm not sure you answered my question about groundwater management districts in retrospect. That is, again, using the same kind of perspective. And I realize you may not be as intimately involved with the GMDs, you know, today. But what is your perspective on how has that GMD local control idea worked? Has it been a success? What do you think about that? Do you have thoughts about that?
Yeah, I think in retrospect, and this is what I said in that symposium in 2006 or so, when that was the question: does groundwater management work? But I said that in the sense that we have attempted to manage, we have slowed down the lowering of the water table. We have controlled any kind of unhinged pumping without any kind of regulation at all. I mean, before 1945, people could just pump as they wanted to. And in fact, really until 1979, when they made it a crime to divert water without a permit, you could still pump without any kind of repercussion. Then in 79, or 78, they made that change. So I think that, yes, I think that it has added some predictability. GMDs have stopped new permits in some areas, and that overall we have slowed down the pumping. I mean, I think it's obvious we're not going to shut it all down, or there might truly be a constitutional issue with the taking of property. But I would say overall, they have been beneficial. Now, let me just add that the reason for that symposium that we had, Rex, was that I attended an international meeting in India a couple years before that. And there was an international expert from India who one of the subjects of the day was groundwater management. And he said, frankly, I don't think I've ever seen groundwater management anywhere in the world that works. And I wrote him later, and his name was Tushar Shah. I said, Dr. Shah, would you mind coming to Kansas to defend that statement? And so we brought him to KU. And at the symposium, we had Burke was a student then. Burke Griggs was a student, and the editor of the journal that sponsored that symposium. But we had Lee Rolfs and Wayne Bossert, I think, and Mike Ramsey, and some other people who came in to talk about the history of our GMDs, and I basically said what I just said to you a minute ago, that yeah, I think overall they've been beneficial. Well, Tushar Shah said, well, maybe they have, but he says, look, you have spent literally millions in administrative costs. I mean, when you think about the salaries, I mean, it's millions we have spent. And he says, your groundwater tables are going down. He said, in India, we have spent zero. Our water tables are going down. So have they worked? I think they have, but Tushar was very skeptical.
You've clearly worked with a lot of the administrative machinery in the state, and in various roles as consultant and representing other interests. What about your legislative interaction? Were you involved? How have you been involved with the legislature in this process?
Very, very tangentially. You and I were talking about this the other day, Rex, that I am a lawyer, but I am a transactions lawyer. I did not become a trial lawyer, in part because I do not like direct disputes. I like to work and understand problems and work out deals. So my involvement with the legislature has been very limited. If I recall correctly, I've never actually testified on a particular bill. I could be wrong there, but most of my experience with the legislature has been invitations to speak to some committee, but to give a general overview of water law to educate mainly the new legislators.
Basically informational hearings.
Exactly. And in a couple instances, I actually, at the legislature's prompting, worked on a report. For example, when we proposed some changes, or when the legislature thought that the original 1983 Water Transfer Act might need some amendment because nobody was using it, the legislature asked KU and the water office, basically, could somebody do a study? And so a student and I did a study of the Water Transfer Act, and we proposed some amendments that were adopted to change the Water Transfer Act. So it would be that kind of thing that I would have worked on.
And
but unlike you, who had to go in and face the ire of the legislator, I just would go in and people would ask polite questions. And so my experience was always very positive.
But the upshot of that is then you become, in their eyes, sort of the credible, objective expert that they can go to with questions. And the upshot is they really listen to your answers and are guided by those. That was my impression from what I saw in that process. Is that how it felt to you?
Well, that I don't know. I don't have any way to gauge that. But I have been asked several times to return, but certainly not like you have been and others who have to go in there and defend potential legislative changes.
If you could, I think I've asked you this question in the past, John. But if you could wave a magic wand and change something, change some aspect of Kansas water law today, what would it be? What do you find most problematic as the way
I don't
the
think you've
laws?
asked me that before, Rex.
Really?
In a way, I wish we could go back to 1945 and foresee the groundwater depletion and try to control it at the beginning rather than retroactively, like we've tried to do. I mean, in 45, we set in motion the requirement that for people to get valid property rights, they had to apply for a permit. And then, of course, the center pivot irrigation inventions were coming in, and all of a sudden the groundwater revolution exploded, and so did the permits. And I don't think the division early on was very conservative in granting permits. I think
that's an interesting way to put it. Yeah.
Well, and you know, I'm not blaming them. I mean, it created a huge industry. So you've got the tension of the economics on the one hand and the protection of the groundwater on the other hand. But it's hard for me to say right now what we could do. If we could have done something back then, like we do now. I mean, the chief engineer won't allow a permit with the various 2-mile radius well spacing regulations we have. If we could have had that back then, rather than the general statement in the Water Appropriation Act that allows the chief engineer to grant a permit if it's in the public interest and if it doesn't affect any other water user, senior water user adversely. That's really loose.
Then let me ask the question this way. The driving foundation of Kansas water law is priority and time. Should it be? I mean, should all that matters, I mean, and I know this may not be completely true legally, but in effect, the main thing that matters is when you have a water right. Should it matter how you want to use that water? And this is something I know Joe Harkins has talked about is the possibility of, say, reserving a certain number of water rights for industrial, municipal, or whatever other kinds of users, as opposed to just strictly first in time, first in right. Any thoughts about that or not?
Well, I'm not an economist, but the way it has been explained by the people with a lot more economic sense and knowledge than I have is that the market just takes care of that. In other words, if we get to the point where cities produce more value than nearby irrigators, the irrigators will sell their water rights to the cities. That's of course happening. And so there are some states that do regulate use more than we do. That is priority of use, or it's not priority. Priority is a time idea under Kansas law. Preference is the gradation of uses. But some states try to do that by legislation. Most of the Western states have let water rights just evolve, and then they are changed as the economic situation changes. And that's, I think that's a pretty good argument, but I don't know.
Yeah, and there is some of that cities or municipalities purchasing water rights and basically diverting that water from, say, irrigation, that sort of buy and dry process. How does Kansas stack up, do you think, in terms of water law compared to other states? And I realize every state is different, every situation is different, and it depends on what you're trying to accomplish. But every state is different, even though most states in the West subscribe to Western water law. every one of them is different in various ways. How do you think the Kansas approach stacks up with other states?
Well, I'm biased, but I have such admiration for the people in the Division of Water Resources over the decades, starting with David Pope and Lee Rolfs, who for 35 years or so guided us in that department. And I think with respect to groundwater regulation and with respect to administration, that Kansas has been a model and is respected by other states and other countries. I mean, we have broadcast our methods in other countries. Rex, you and I were together in India where we did that. And I think we have a good system. And David Pope has done a good job of attempting to strike a balance between just total strict adherence to the prior appropriation doctrine and trying to accommodate other interests in other situations. But I think we're highly thought of. Now, I think you'd have to ask people outside the state what they think, but
yeah, and it is always sort of interesting because I will sometimes hear folks in Nebraska talk about how they think they've got the best system, and I look at what goes on up there and sort of scratch my head about trying to rectify those two statements. But hey, one other thing, John, again, priority in time is the driving force here. One of the things that I've always been sort of surprised about is the lack of impairment complaints as particularly the Ogallala is drawn down. It's clear that there have been impairment complaints and there have been lawsuits as a result of those impairment complaints. But by and large, irrigators, who are the big water users out there, as those drawdowns take place, they are getting impaired, but they are clearly reluctant to file impairment complaints. Why is that? And I realize your answer might be, well, go ask them, but
it is. but Rex, a couple things. I don't know. My sense is that Kansans are not just inherently litigious people. I mean, the farmers that I grew up with, I wasn't raised on a farm, but I worked with a lot of farmers in the Concordia area. In fact, that's where I saw irrigated corn for the first time, and it's just in the Republican River Valley. But I just don't think they're very litigious. And, you know, in some cases, I think that lawsuits aren't filed because one farm or one person may own 2 or 3 water rights. Some are junior and some are senior. And in fact, I think that probably happened out in the Cheyenne Bottoms where you had so many 800 or so irrigators. There were probably people with senior rights and junior rights. I know there was a case up in the Beloit area called File versus Solomon Valley, where some of the plaintiffs were named File and some of the defendants were named File. So that's an unusual case where you're suing your own family members. So I think people are really reluctant to sue their neighbors. And there is a recent case, as you know, that actually went to the Supreme Court in Kansas, an impairment case that's kind of the classic where you have a senior vested right suing several other irrigators that are junior within about a 1.5 mile radius of that farm. And that's very unusual in Kansas.
It is unusual.
It surprised me over the years too, Rex, that there isn't more of that.
Yeah, and I think you're right. Some of it is maybe the non-confrontational attitude that most Kansans have. Those family connections were involved in some of the lawsuits that you're talking about too. It's pretty difficult to sue your own family in that process, and nobody would want to do it. I always thought the lowering of the Ogallala would be the equivalent of the Full Employment Act for lawyers, because it would lead to so many impairment complaints. All of your students and all of their students would have more business than they knew what to do with. But that has not been the case. And the upshot in some respects, I think, is probably encouraging decline in water levels. Isn't that one of the?
You know, I think another reason that we haven't had more litigation is that it's one thing if you're on a stream and you have a downstream water right and some upstream user pumps a large amount, you can immediately see the effect. It's another thing if you're out in the Ogallala and you've got hundreds or thousands of irrigators that are different distances apart. So it's harder to prove. But I agree with you about kind of the surprise that there isn't more work for lawyers. And I remember early on, one of my law faculty colleagues said, "John, you're going to be in water law." He said, "It reminds me of the scene from The Graduate where the friend says, you're in plastics," or he said, "Get into plastics. That's going to be the future." And it probably was in plastics. But in Kansas water law, you know, I can count on the fingers of two hands the number of former students I've had that I know either have or practiced water law. And there are outstanding lawyers. In fact, I wish I wrote down a bunch of the names of the people in anticipation of your questions today that I've interacted with. And I think it'll be a shame if I can't mention some of those. But
well, go ahead. I just have this vision of somebody, instead of saying plastics to you, saying water. That's what
it was.
That's what it always seemed like to me too. So who is that cast of characters? Because certainly, boy, whenever you talk about, it's impossible to talk about water without talking about a range of other disciplines, economics and sociology, and all of those kinds of things. But the law always jumps into this issue. I live in the world of the geology, geohydrology world, and yet the law seems to be just as important to what happens out there as the physical presence of the water, which somehow was a little surprising to me when I first started worrying about this world. But so there are a whole cast of characters like Lee Rolfs is somebody that immediately comes to mind, and your name comes up, and Mike Ramsey's name comes up out in the Garden City area. Dave Traster, some of those kinds of folks. The Kansas versus Colorado lawsuit and the lawyers involved with that. So who else is the cast of characters here?
Well, you mentioned Mike Ramsey, but he was in my very first water law class. When I admitted to my class, I don't know much about this subject. We're going to learn together. And then Mike came up after class and said, "Well, Professor Peck, I grew up in an irrigation farm. I have a degree from K-State in ag engineering and a master's in irrigation science from the University of Arizona. And I'm here because of this course. I'm in law school." And I said, "Well, that's no pressure." But in any case, Mike has become a close friend and confidant, and sometimes on the other side of a case that I've worked on. But I admire him as maybe the finest water lawyer in the state of Kansas. And in that group would be Dave Traster, Ken Titus, now is a former student of mine, now head of the Department of Agriculture's Legal Division and DWR, Rebecca Liggett and Don Pitts and Connie Crittenden Owen. Those are the people who worked inside this system. Well, David Traster has worked on the outside. Adam Dees, who's now an up and coming water lawyer who represented GMD4 recently. And then all of the people that I've worked with in the state, starting with Jim Power and then Bob Smith, and then Guy Gibson used to come to my class before David Pope became chief engineer, and David Barfield later on. Let me just check a couple things here, because I wrote some down that I don't want to forget. In the KGS, of course, you and Don Whittemore. Bill Hamilton I knew but didn't know well. And then the GMDs, Mark Rude and Wayne Bossert. I forgot to mention Mike Armstrong, who's the head of Water One in Kansas City, is a former student of mine. And I just feel real fortunate to have been able to work with all these really, really good people, nationally and internationally too. As you know, we had a trip to India together. And Rex, before we forget, I wanted to show you a cartoon, a political cartoon that came out in the Wichita paper after the Cheyenne Bottoms case. I meant to show you this when I was talking about the Cheyenne Bottoms, but I don't know if you've seen this or not. Can you?
You got. I think you have to hold it up higher. And I see somebody flying over in a Cheyenne Bottoms. I think you're going to have to read us what the cartoons say, though, John.
Okay, so this is a cartoon that appeared in the Wichita Beacon after the Cheyenne Bottoms decision came out, and it shows two ducks down in the Cheyenne Bottoms with their celebratory hats on, and balloons, and a big sign that says the Cheyenne Bottoms Water Rights Victory Party. And the two ducks are talking to each other, and meanwhile overhead are these people flying, and one duck says to the other one, "Whoa, what kind of migratory fowl are they?" And the other one said, "The worst, lawyers for the farm interests." And I cherish this cartoon because I figure I'm one of those people up there, but also because I contacted the cartoonist. I just thought it was such an interesting cartoon, and I said that I'd like to have a copy of it. Actually, what happened was my students in one of my classes, when I just printed off a copy, called the Wichita Beacon guy and said, "Can we buy that original?" And he said, "Well, for $100." And they said, "Well, can't you send us something else for less?" And so for $10, they sent them a very nice print that's this size. And I have that hanging up in my wall in my office at KU. I love that cartoon.
Well, it's always nice to know what value you're worth at that point. Somewhere, more than $10 and less than $100, I guess. But actually, the other thing, though, it does sort of tell you is, when an environmental water issue rises to the level of a political cartoon, that shows you, again, and I say this every chance I get, the important role that water plays in the state. And I think it's so important and so ingrained that sometimes we don't even think about it. But I think it just dominates this state in different ways from one end of the state to the other, in ways that people maybe sometimes don't appreciate as much as they should. When I talk about water and water law, sometimes I can see people sort of roll their eyes and, want to walk away. And yet I find that intersection of the law and economics and science and agriculture to be just a fascinating place for a lot of really, really important conversations and decisions. And so I think with that, John, anything we should touch on that we haven't talked about at this point?
Well, I sent you an email saying I'd like to just mention the international work,
Okay.
although the only thing that has done really is to broadcast what we do and to allow people to compare our systems with their systems. And Bert Griggs, who is another student that is one of my former students, top students, former head of the legal department at the Division of Water Resources, now a real, truly nationally known scholar at the Washburn Law School. Burke helped me with a couple projects. One was that conference that we had, that symposium I mentioned. And then we brought a group of 6 Asian experts, water experts, to KU for 3 weeks back in about 2008, I think it was. And you were a big part of that. You were a big part of that because you helped lead a field trip that lasted 2 or 3 days over Kansas. And what what we did with that group was to show them what we do and what we have. And then each of the members of that group, those 6 Asian experts, presented what their countries do. And we did some comparison. And out of that came 2 articles that Burt Griggs and I published together on the subject of comparative water law, which I think is important.
You know, the other part of that, John, that still sticks with me that I think about a lot was was watching the reaction of that group of folks when we took them out to Western Kansas. Their reaction, both in terms of water and water law, but also just their reaction to the place itself, because most Americans already have this viewpoint of what they think they're going to see when they go to Western Kansas. And sometimes it fits, the reality fits what their preconceptions, sometimes it doesn't. That group of folks, I don't think had any idea what to expect out there. And their reaction was unlike anything I've ever seen from any group of people I've ever hung around with out there. I still think about coming back and their reaction to the emptiness in parts of Western Kansas, to the point they were almost frightened. I've just never seen about anything like that, and it helped me look at the place differently too. So,
well, I might mention that the countries represented were India, Bangladesh, Nepal, and China. That's where the group came from. But Rex, back on the question about people's perception of water law and boring and that kind of thing. How do you think I feel when I meet somebody new and they say, well, what do you do? And I say, I'm a lawyer. Well, what kind? They expect trial lawyer or tax lawyer or something really cool like corporate lawyer, environmental lawyer. And I say, I'm a water lawyer. And I get blank stares all the time and have to explain that unless the person I'm speaking to is from, say, west of Highway 81. And otherwise, nobody knows about it.
I know what you mean. Yeah, actually, usually if you tell somebody that, they start looking for the nearest exit or somebody else they can go talk to get away from you. I have a good friend who occasionally, Burt Griggs and I and Don Worster, who you know from KU History Department, who's done a lot of work in water, would get together with a 4th guy, and Don and Burke and I would begin to talk about the arcane details of water and water law. And the 4th member of this group would immediately run for the exits because he just couldn't take it. And yet to me, it's like I could listen to people talk about some of these things all day long and be still ready for more. And I'm sure you are. Well, John, I appreciate you doing this. I think you're a pretty key component to this whole conversation, and one of that member of cast of characters that you walk through, whose names people are still going to be talking about. And this conversation we had will then give them some background, I think, to do that, and maybe helpful even to some maybe some future law students too. So I do appreciate you doing this, John. You're one of the good guys, and I'm glad you agreed to do this. It's been a good conversation.
Rex, I was surprised, but I'm just honored to be in a group of water people that you would consider interviewing. So thank you very much.
Well, thank
you,
John.
And the Historical Society.
Thank you, John. Appreciate it.
Thank you.